want to introduce Michael Holberg, the chairperson of our Adult Education Committee and the organizer of this wonderful program.
Thank you, Rabbi. It was a beautiful service and abbreviated. And thank you, Molly. Beautiful singing. And Charmaine, you look great. Before I introduce our distinguished speaker, I'd like to say a couple of things. First, I'd like to welcome my close friend and lawyer friend of mine, John Tyson, the former district attorney of Mobile County, and his wife, Beth. Thank you for being here. I knew you would be interested in this. And I also would like to say, before I introduce Professor Gerhardt, that this night would not have been possible but for Irving and Frances Silver. A couple of years ago, I understand that the Silvers made a generous donation to South Alabama and to establish a speakership series that was to have as their first speaker, Professor Gerhardt. And Irving approached me and said, I wonder whether the temple would be interested in seeing whether Professor Gerhardt would have some interest in speaking at the temple before or after. And I said, that would be wonderful. And we did, and we set it up. But unfortunately, COVID got both of us. And as far as I know, he has not had a chance to speak yet at South, but we are very fortunate tonight to have Professor Gerhardt with us. So thank you, Irving and Frances. Before I welcome Professor Gerhardt, I'd like to welcome another Professor Gerhardt, Michael Gerhardt's bride, Professor Deborah Gerhardt. She, like her husband, is a noted and well-recognized legal scholar at the University of North Carolina School of Law. I've got to also admit that in preparation for the introduction tonight, I had a chance to find and review Professor Gerhardt's 33-page single-spaced CV. This is not a joke. If I were to read that CV, we would be sitting here till 10 o'clock and we wouldn't have time for his presentation. So I've made just a few notes about some of the highlights. Professor Gerhardt is the Burton Craig Distinguished Professor of Jurisprudence at UNC Chapel Hill School of Law, where he has been teaching for the last 16 years. His teaching and research focuses on constitutional conflicts between presidents and Congress. He is the author of numerous books and leading treatises on impeachment, appointments, presidential power, Supreme Court precedent, and separation of powers. He has written more than 100 law review articles and dozens of op-eds in the nation's leading newspapers. He is known throughout our nation as one of, if not the foremost expert in these areas. He took his undergraduate degree at Yale, graduating cum laude, then the University of Chicago School of Law, where he again graduated cum laude and Order of the Coif, and then the London School of Economics. Thereafter, he clerked in the U.S. District Court for the Western District of Tennessee, and then the U.S. Circuit Court of Appeals for the Sixth Circuit. He has testified more than 20 times before Congress. He has served as special counsel to the U.S. Senate Judiciary Committee for the appointment of 8 of the 9 sitting Supreme Court justices. He has been an expert commentator for CNN, MSNBC, and Fox News. He is a 1974 UMS graduate, class valedictorian. I also went to UMS. I was not the class valedictorian. They called me the 6th man on the basketball team when we had 6 people on the basketball team. I was somewhat undistinguished. And he was also a 1972 confirmand of this temple. I presume he was first in that class too, but I haven't seen the records to confirm. In short, we are delighted to have both Professors Gerhardt with us tonight. Please join me in welcoming him back home and to enlighten us on why U.S. Supreme Court confirmation battles are worthwhile. Professor Gerhardt.
Well, thank you. You'll have to give me a minute or two just to come to terms with the incredible passage I've just had. There is no document more boring than my resume. But what is particularly striking is that I think, announcing the fact, and I thank the rabbi and the bulletin for this, and Michael's made reference to this as well, in announcing that I was a 1972 confirmand, you really made me think about the fact that this year marks the 50th anniversary of when I last stood here. And the fact that no one here knows that pretty much tells you the significance of that fact. But I feel it. I can't really fully, I guess, recognize just what those 50 years have marked, and not just my life, but in the constitutional life of this nation. I also am struck by the advancements in technology over that time period, and I want to thank the synagogue and Zoom for letting both my wife and I know that one of our sons is alive, because we just heard his voice. I'm talking about you, Noah. I'm also moved, almost beyond words, you could have been lucky there, to recognize a number of people whose faces I recognize: Roy, Mimi, others, Glenn, Sherry. I'm grateful that you're here. I'm grateful for those on Zoom, Leslie, among others. My mother-in-law, I think, is there as well. And all of that really brings home the fact that while I have not been back here in decades, I was reminded of the importance of Mobile in my own life when one of the greatest, really, sons of Mobile recently died. E.O. Wilson, the fabulous evolutionary biologist who not only grew up here, but was renowned throughout the world as a Harvard professor and as really the world's leading naturalist. And one of the things that E.O. said was that no matter where I went, I always felt that I really was home in Mobile, and that's where my spirit is. And I feel the same way. I may have left here, but I have always identified myself as a proud Mobilian, son of this city. I stand where my parents stood. I stand where my grandparents stood. I see the house that they helped to build, and all of you helped to support. And I am grateful for that. And even though they're not here to express their own gratitude, I am here for the legacy and the extraordinary mission that all of you have been on in very difficult times. Those past 50 years have gone by like a flash. And yet I remember so much of it. And so much of it really defines the moment at which we are now meeting. In those 50 years, we have experienced the first time a president resigned from office. In those 50 years, the Supreme Court decided a case called Roe versus Wade, a case that is now embattled on the Supreme Court of the United States and may well shape part of the remarks I'm about to share with you. In those 50 years, we've also seen other scandals, the Iran-Contra scandal, and more recently, what I will describe, I think quite factually and accurately, as the insurrection of January 6th, 2021. That's just the beginning of it. Those 50 years also mark the first time the Supreme Court of the United States really certified the outcome of a presidential election. That's a case called Bush versus Gore. In those 50 years, we also saw the Supreme Court move from having a majority of justices appointed by Democratic presidents to a majority of justices appointed by Republican presidents, and that is the case now. From 1969 to the present, Of course, the court has had a majority of justices appointed by Republican presidents. That has helped shape the path of the Supreme Court. But as Michael's overly generous introduction suggested, much of my concern and focus over the last 50 years, not just in growing up and becoming whoever I am, incidentally, I really should thank him for the single most important acknowledgement about any achievement in my life, and that is the fact that this year also marks the 25th anniversary of our marriage. So it is an important year, important occasion, and knowing that I have at least one son listening, if not more, gives me the confidence to go forward. I also want to thank Justice Stephen Breyer, because he's just announced he's leaving the Supreme Court. And that makes this talk especially timely. We can expect later this year to be thermonuclear war in the United States Senate. And I can say that because I've been there before. We can expect that what's going to happen is almost really foretold. It's like a script. We have already begun to hear how awful and dangerous the Democratic nominee will be. And heavens forbid, it appears it'll be an African-American woman. And that's an awful thing for minorities to have singled that out for distinction, even though over the course of American history, most Supreme Court justices, over 90%, have been white men. A small number have been Jewish, a smaller number have been African-American, and an even smaller number have been Hispanic. Progress in the United States is usually marked by the fact that we, the people, is perfected more than it has been before. We, the people, has never been a closed set. It's always been a welcoming family. And it has welcomed more people over the course of time in American history. Just in those 50 years, we've seen it. We've seen it happen in the civil rights movement. We've seen it happen with, frankly, the ongoing, and deservedly so, ongoing movement for women to achieve equality in the society. Something I have to acknowledge has not yet been done. And if you do not believe me, you should sit down and have a conversation with Kamala Harris sometime. I'm sure she could agree with me on that. We have never gone as far as we think we have. And I think this year will remind us of that. What I expect will happen is this. We will see, beyond the comments I've already shared with how awful the nominee has been, we'll also hear about how great the nominee has been. Certainly making history, certainly deserving a seat on the Supreme Court of the United States. And we'll also hear about what is at stake in that event. And this is no overstatement, is the Constitution of the United States. Over the course of those 50 years, what I think has distinguished many of us, what all of us I think have strived in many respects to be, is to be responsible to a higher power. That is the mark of people who achieve and seek out public service. And that is the mark of people who seek to shape and control the Supreme Court of the United States. It is to see whether or not we can find people who will answer to a higher power. In my life, that higher power has been my wife, my children, and my 2 dogs. That's about where I rank in the house. Maybe lower than that, it's hard to say. But also, I think what we hope is that the people that we find that will help shape and guide us, instruct us really about the Constitution, the highest civil power there is in our country, we hope that the people who will do that will actually be mindful of something beyond their own political and personal preferences, that there's something more important than just their success at stake. There is at stake the future of our Constitution. And that is, in many respects, I think, what we'll see battled over probably within a month or so. And even though it's all choreographed, it will be instructive. And this is why I suggest that Supreme Court confirmation battles, though they're ugly, they're nasty, they're filled with lies, they're filled with hate, they're occasionally filled with promise, they will instruct us. They'll teach us something about an institution that is remarkably unaccountable to the American people. The Supreme Court of the United States consists of 9 justices who are appointed for life. And that has led many political leaders to do is to appoint people to the Supreme Court who are barely out of law school and have not lived a very rich professional life, and who are largely, I think, feeling accountable, not so much to the Constitution, but to the people who put them there. That is not what I think the Constitution demands of us. I think it demands of us something better. And so I just want to talk about some of the different issues that will be at stake, I think, later this year, that are really at stake right now, that I think define our passage and will help define where we'll go over the next 50 years. One of them really has to do with women's rights. There's no question about that. I actually think this audience is perhaps the best qualified of any in this country to measure how far we've come in the last 50 years. Because as I mention each of these issues, I think you're going to realize they're the same issues we talked about 50 years ago. The more things change, the more they don't. So women's rights were, of course, crucial every time in American history. They were crucial in 1972, the year in which the ERA would die a little later. But the Supreme Court itself began issuing a series of decisions around about that time that actually created protections and guarantees for women, not just in terms of health care and reproductive services, but in terms of workplace equality and being treated as equals before the law. Today, I think it's fair to say that women face challenges, not just in the private sector, but in the public sector, where I think we see legislatures, dare I say, even in Alabama, trying to exert control over women's lives. That is a fact. And that fact hasn't changed over the last 50 years. We've also seen a remarkable, and perhaps, however, not so surprising, development of the Supreme Court in addressing issues of church and state. There is no issue more important to the Supreme Court these days than religion. And religion has become the basis for the Supreme Court striking down and narrowing the scope of a number of federal laws. That is no accident. And it's not an accident that the Supreme Court, as it's currently composed, has 6 Catholics and 3 Jews. That's the most number of Catholics ever to sit on the Supreme Court in history. It's the most number of Jews ever to sit on the Supreme Court in history. It is not an accident. I think that composition is largely the result of the fact that as presidents have gone out to seek the people who will rule as those presidents would like, and by the way, every president wants that. Every president, from George Washington to the president, has wanted justices who will rule like they would have wanted. But if you're looking for people who are committed not just to, let's say, a right to life, but who are committed to ensuring that women will not have the complete freedom to make choices about their own reproductive services, you're going to find that reflected in some groups more than others. And what you want, if you're president of the United States, is somebody who is so committed to their ideology that facts will not change their opinion. That's the Supreme Court we have today. It is not an overstatement to say you don't even need to argue cases before the Supreme Court. You already know how they'll turn out. I can tell you every senator in the United States Senate knows something that law students don't really recognize. Lawyers sometimes have a hard time acknowledging, but people generally get. And that is the fact that justices are not superhuman, and that justices will, in fact, be influenced and shaped by their lives and their experiences, by their religious and other commitments. That's a fact of constitutional life. And so we have a court consisting of justices who are largely appointed, and this is a good thing, I think, because it's not happened in secret. They've largely been appointed to reverse Roe versus Wade. They've largely been appointed to allow for more religion in public life than has been the case before. When I was here in high school and in the synagogue, that was a time when the Supreme Court, not long before, had struck down school prayer in public schools. That's not been forgotten by the people making appointments to the Supreme Court of the United States, because the justices we have now want there to be more religion in public life. That could be a good thing. The question is going to become, how good is that for people who happen to be a minority? How good is that if you happen to be a member of a religion, let's say this congregation, and your religion is not the one that's being recognized and given priority and given protection by the Supreme Court? I'll give you an example of this in a relatively recent Supreme Court case. And what I'm about to tell you is the real case. It may sound outlandish, it happens to be true. Truth, by the way, is always stranger than fiction. This case involves a large sort of, I guess, mountain, or it's probably more of a mountain than a hill. And at the top of that mountain is a gigantic cross. And in the case, the question before the Supreme Court was basically, is that cross a symbol of Christianity? Because if it is a symbol of Christianity, then it would violate the Supreme Court's prior decisions against the establishment of religion. Erecting a cross on public property is, according to past Supreme Court decisions, the endorsement of a particular religion. In this case in the Supreme Court ruled that the cross was not a symbol of Christianity, but instead it was really a symbol of all religions. You don't have to make this stuff up. Now, you don't have to be a lawyer to think there's a little something odd about that. And my friends, and I have a number of close friends who are Catholic, and I've gone to their weddings, and they are as close to me as any people I have in my life. My mother, by the way, was finishing up her college education at Spring Hill, so I have every respect in the world for Catholicity. But I think it would be a surprise to devout Catholics and devout Christians that the cross symbolizes something other than their faith. Of course, it's a religious symbol. I mean, sometimes if it looks like a duck, quacks like a duck, and walks like a duck, it's a duck. Now, in law, we have the magical ability to say sometimes it's not. Like with a cross, we can say, well, it looks like a cross, it functions like a cross, it feels like a cross, but guess what? It's not really a cross. Well, that's not good for constitutional law. That's not good for the country. That's not good for the Supreme Court. And it's probably not good for those people who are not Christians. But that's the challenge we currently face. Religion now is being used, I think, in a way by the Supreme Court, quite purposely, to find the outer limits of federal power. So, in the Affordable Care Act, dare I mention that? and in other pieces of federal legislation, the Supreme Court has consistently found that religion has to trump, and that's just a coincidence, I'm using that word, that religion has to trump any other interest as far as the federal government is concerned, and therefore the federal government can't require businesses to do things like make people wear masks in the midst of a pandemic, pay for reproductive services for their employees. Apparently, religions have a lot more detailed convictions as it relates to social policy than I ever possibly imagined. But that's the case now. I don't think that's a partisan statement. I think that is a descriptive statement of how things stand. The only difference between me and somebody who would criticize, I think, what I'm saying is, well, they will think it's a good thing, not a bad thing. Now, in my profession, and I dare say this, I'm supposed to be a legal scholar, there's not supposed to be things like good and bad, good and evil. They're not supposed to be things like right or wrong. They're just supposed to be things that are constitutional or not. And if there's one institution of government that is challenged to, let's say, protect the Constitution, that's challenged in a sense to hold the Constitution dear, that institution almost always will consider to be the Supreme Court of the United States. Now, in this lecture, I want to tell you that that is a mistake of law, that if you think that. If you think the Supreme Court is the only institution that cares about the Constitution, we are already lost. The president has to care about the Constitution. And if the president doesn't care about the Constitution, we should hold the president accountable. I am silly in thinking that is the proper way for the Constitution to be administered. And here is where I veer off track and say, on a day when the Republican Party declares that January 6th was a day when people just came to the Capitol to engage in legitimate political discourse. Well, as my wife Deborah knows, I was in Washington on January 5th. I was meeting with some senators talking about what we could do about the fact that the current president was interfering with the electoral process and still trying to sort of undermine the election of 2020. And I drove home on the 5th. My favorite moment in Washington is always when I see it in my rearview mirror. I went home on the 5th and I returned on the 7th. And I returned on the 7th, and here's what I saw. This, by the way, is a fact. I am not making this up. There were 12-foot-high fences all around the United States Senate. There were National Guard everywhere you could see in the vicinity of the United States Senate. And by the way, we were in the middle of a pandemic at that time too. I could not walk into the United States Senate without going through dozens and dozens of National Guards people. And I was in Washington from the 7th until relatively early in February. And as I went into the Senate, and I was asked by Patrick Leahy to be his special counsel when he was the presiding officer in the impeachment trial, and I was honored to do that. But as I went in there with Senator Leahy, I can tell you something that's factual. There were broken windows. There were broken doors. There were broken passageways. There were defaced statues and artwork that is priceless. And when later I sat behind Senator Leahy during the impeachment trial, in the chamber of the United States Senate, as I looked out on that, as I do now, I saw wreckage. I'm pretty sure the senators didn't commit that wreckage. I'm pretty sure the people that stormed the Capitol on January 6th did that wreckage. The question is very simple for we lawyers. Who's responsible for that? And then the next question is also relatively simple. What does the rule of law require that we do with people that storm the Capitol? I think the answer is not that we should lie. We should make up stories. We cannot have a constitution. We cannot have a rule of law. We can't be a country that believes in a constitution if we think that lies and fiction are more important than the truth and facts. Being a lawyer means I'm part of a profession that believes in facts, believes in evidence. It's odd that I would say that in a spiritual place, but that's my curse, to be a legal scholar. So I go where the facts take me. I go where at least my understanding of the truth may take me. But as I sat there behind Senator Leahy, even watching the film at one point showing how Eugene Goodman, the extraordinary security officer in the Capitol, was taking Senator Schumer, who was really then the majority leader, down one hall, and then you could see there's 10 seconds of silence, nothing, and then they come running back. And then after they come running back, you see a group of people. They were not tourists. How do I know they weren't tourists? Because they had weapons. And they were chasing people. I'm pretty sure they were chasing Schumer not to shake his hand. As lawyers, the question becomes, what are we supposed to do about that? And so this is a long way of saying that as we prepare for this next March, or this coming March, to consider the next appointment to the Supreme Court, we have to think about what is the importance of the rule of law? Do we care about it at all? Should it make any difference in our lives at all? Or should we just put away all the paper? Just put away that scrap of paper. It's not the most scintillating document to read. Put away all those thick books with statutes. Put away all the case law and just realize that the best answer for any of us is just do what the president tells us to do. You know, if he says beat somebody up, okay, that's fine. If he says the law doesn't apply to me, we say, okay, well, that's fine. Incidentally, in a country that rebelled against a king, it's odd to think the Constitution of the United States would protect the establishment of a king. I'm pretty sure after 40 years of trying to study the Constitution, I'm not the best student, but I'm pretty sure after studying it for 40 years, the one thing the Constitution was not designed to do was to establish an unaccountable political official in the federal government. That counts for the Supreme Court, counts for members of Congress, and it sure as heck counts for the President of the United States. Sorry, Rabbi. That was my version of a curse word. But how do you do law? How do you try and stay faithful to a higher power that we call law? How do you do that when the other side doesn't? That is the challenge that now faces us in the nation's capital. That is now the challenge that faces us as an American people. That is our quandary. That is our challenge. This is not a popular message, I think, for some people to hear. It may not be popular because you may think the greater threat is really those darn Democrats, those darn liberals. Everyone is entitled to think the other side is filled with blasphemies. But I don't think what everyone's entitled to do is to take the law into their own hands. I don't think everybody's entitled to turn the Constitution into whatever they think it ought to be. I don't think they're entitled to shred it. I don't think they're entitled to shred the rule of law, because it is those things, the rule of law, the Constitution, that have made the American nation what it is. That is why we fought a civil war. That is why we've endured the outcome of the Civil War. That is why over the last 50 years, we've had a number of movements, civil rights movements, feminist movements. Another significant movement, the gay rights movement. We've had all those things. And I would say they have expanded who is we the people. And they have made the American family broader, more welcoming, and stronger. Progress is frightening. And it is certainly true that sometimes we have to fight against progress because we should preserve certain traditional values. All of that is completely fine with me. It doesn't matter to me as a constitutional law person that that would be anybody's set of preferences. All I care about is very simple. I just care about people remaining honest and truthful and open and candid about the law of the land. And so when this confirmation, now what does this have to do with confirmation? Because the Supreme Court confirmation process is actually all about that. It's all about trying to make things open. It's all about trying to put a spotlight on government officials. Would you rather have a Supreme Court justice chosen in a back room whose name you never knew, whose face you never saw, whose voice you never heard, make decisions that will change the rest of your life? Or would you rather have somebody chosen that you could see, you could hear, you could listen to? And one of the things that I've discovered in working in confirmation proceedings for a number of justices is something that is contrary to what nearly every other legal scholar will tell you. Nearly every other legal scholar will tell you Supreme Court confirmation proceedings are just a kabuki dance. They don't matter. They're scripted, and whatever happens is just politics. It's political theater. And I will say this as in concluding, that it's all of that. All that's true, but there's more. What you will also discover is that the justices who come to testify will actually tell you things. If you listen closely enough, you will know precisely where they stand, and you will know precisely where they'll go. That is true for everyone who's passed through that process. You can hold up their hearing and then see what they do later, and they are completely consistent. It just requires listening carefully enough. So, for example, when I was there during the confirmation proceeding for Justice Neil Gorsuch, there were certain things Neil Gorsuch didn't want to say. And I remember working with Senator Richard Blumenthal and talking about a case called Brown versus Board of Education. And I said, Senator Blumenthal, I don't think Justice Gorsuch is going to say that's rightly decided. Senator Blumenthal, himself a former Supreme Court clerk, looked at me and said, you got to be kidding. I said, well, I just think that's what's going to happen because Brown's a terrible case for somebody like Gorsuch. And he said, why? It's because it's a case not grounded in original meaning. Senator Blumenthal asked Gorsuch, do you think Brown was rightly decided? Gorsuch would not answer the question. After pressing Gorsuch for a while, after the senator pressed Gorsuch for a while, Justice Gorsuch said, well, I think it's a case that can be squared with the original meaning. That's what makes it, that's what makes it a good case. And then Senator Blumenthal, I think, kind of looked a little bit back and I said, and I had highlighted for him the language in the Brown opinion in which the court says the original meaning is not helpful here. Now, we have a Supreme Court justice saying one thing about Brown. We have Brown itself saying something else. The important thing there is to recognize those two things are not the same. And the differences are revealing. It's the revelation that matters. And the revelation in that circumstance is that we know that Justice Gorsuch will use original meaning to get where he wants to go. It's that simple. Is President Trump entitled to nominate somebody who will do that? Absolutely. There is no question about that. But is President Biden entitled to nominate somebody who won't do that? I would say absolutely. He's entitled. That will be the difference that you will see and hear coming up. I have a feeling I've talked too long. By the way, this is about the size of my usual class. and you're taking notes about the same as my classes usually would. But I find the most helpful part of any class, any experience, is the opportunity to talk together. So I'm open to taking criticism, comments, or questions. Anything else you like? You don't have to ask questions. Yeah.
So, one of the potential candidates for the Supreme Court apparently received overwhelming Republican support in her confirmation battle for
Right.
one of the 13 federal appellate courts.
Right.
And should she be the nominee, do you think that those Republicans in the Senate that voted to confirm her to the circuit court are going to backtrack and somehow find a reason to vote against her from the U.S. Supreme Court if she's the president's nominee?
Yes. Any other questions? Yeah, they will. I mean, I've seen that happen before. It will happen. And why is that? Because the Supreme Court is different. So the Supreme Court is a political prize. It is one of the greatest political prizes in the world. Why is that? It's because if you can command 5 Supreme Court justices, if you can get them, if you know what they're going to do, nothing else matters in the government. Because you can control things for decades, as long as those people live that long. And when you are appointing people who are 45 and 50, they should live that long. John Roberts, who is our current Chief Justice, eminently qualified, really brilliant lawyer, was nominated to be Chief Justice when he was 50. He was the second youngest Chief Justice in American history. The youngest was a man named John Marshall, who happened to be 45 when he was appointed Chief Justice. Now, 45 at that time, 1800, wasn't 45 as it is today. But John Marshall lived for another 35 years as Chief Justice of the United States. I am fully confident, barring any kind of weird accident, that John Roberts will break that record. Now, this is one of the things the Constitution does for us. We will have somebody acting as Chief Justice for probably about 40 years, long after the political party that was there when he got appointed has gone out of power. The Federalist Party, which is John Marshall's party, died while he was Chief Justice. Life tenure means you get these people for decades. That's the power. That's why the stakes are so high. That's why people will do whatever they have to do to get somebody through. And I was there when Justice Barrett went through, and she, by the way, has the record now for the fastest Supreme Court confirmation history in the modern record. That's the modern record. It happened in a matter of weeks, and she was, and this happened in the middle of the pandemic. Very few of us were allowed to go into the room. It was actually quite a logistical success to figure out a way to even have a hearing at that time. But we did. But I can tell you, as somebody who was not just there, but Justice Barrett, as a scholar, focused on a question of constitutional law that is important to some of us. And that question of constitutional law was, this is actually pertinent to the answer, but that question of constitutional law was, how important is a Supreme Court precedent? How much deference should any justice give to a prior decision? And she had written a lot about that. And she had followed in her academic commentary the views of the justice for whom she had clerked, Antonin Scalia. And Justice Scalia, by the way, was my constitutional law professor. So I know what it feels like to have him at the other end of the gun, so to speak. And what Justice Scalia believed and what Justice Barrett had written about was wrong Supreme Court decisions should be overruled like that. Doesn't matter how old they are or anything else. If they're wrong, they should go. That's what she said in numerous articles. In front of the United States Senate, when she was asked about her academic record, she said, oh, in my articles, I always defend the conventional view of precedent. The conventional view of precedent is that precedent should only be overruled when there's a really, really good reason for doing so, not just whether it's wrong. Now, is there a difference between overruling something if it's just wrong and overruling something that, unless there's a really, really good reason to do so? There is a difference between those two things. She just lied in front of the United States Senate Judiciary Committee. What are we supposed to do about this? The answer is we don't do anything as long as the political party that favors her wants her on the court. That's the system we have. And the more we can put a spotlight on it, I think, the better off we are. It will be politics and the future of the court that will move those senators to do what they want. We're a great writer, Roy.
Welcome, Michael. Roy Hoffman, Compliment.
Oh, well, let me turn you.
I hear two kinds of movements of American history in your wonderful talk. The first is all the progress that we've made over 50 years when you last stood here. And then the other, of course, is a nation on the brink, perhaps today, not just a few people questioning some of the concerns that you raised about the constitutionality of the powers that be, at least in terms of the comment about what January 6th meant. You know, we're a very divided country in this. And certainly, you wouldn't have to go far, maybe even within the walls to have debate that. Where are we going with your sons and our daughter and the next generation and the next? Do you feel optimistic? Do you feel hopeful? Are we going to get through this? And because 50 years ago, no matter how many prejudices and no matter how many exclusions there were and so on, that the viability, the power of that constitutional reform, that, you know, we have no change in this country. We're not even the question, no matter what people feel. Where do we go from here? Or are we going to get through this period? Is this the beginning of the downturn of the American democracy and the fracturing of the Constitution?
Thank you, Roy. I mean, and let me thank Roy also for saying so much more succinctly everything I just said. He just translated it into English. Thank you, Roy. You're absolutely right. There is an obvious tension between these two different movements I was describing. I just want to make 2 points about it. One is, I think there's nothing unique about the tension between those two movements. They have always been part of America. That America has never been a straight road. It's never been just perfectly linear. That is not how our story goes. Slavery is abolished at the end of the Civil War. But African Americans after the Civil War are hardly free. That's not the story of Reconstruction. That's not the story that has to lead to the Civil Rights Movement. So, while there may be movement in certain directions, and I would say that's a step toward progress, there are counter movements. That is the American story. The question becomes which of those dictates the future, which leads me to the answer to your question, and it will surprise you to hear my answer, which is I am an optimist. I have to be an optimist. We have to be an optimist. And the reason I tell you the story that I just tried to tell you is because we don't get there. We don't get to be optimistic unless we are prepared to work to protect the values and the law we cherish. It's that simple. There's never a moment, I believe, in America, in American history, when you can take things for granted. The most precious right that any of us has, this is a pop quiz, the most precious right I think every American has is the right to vote. The right to participate and to be heard in their government. And what is under siege in Washington and other states around the country? The right to vote. The only way to address any of that, if you happen to not like the changes going on, is to exercise your right to vote. You must go out in the rain. You must go out, which will never end. You must go out in the rain, sleet, snow, or whatever else. Imagine what Michael Holberg had to do to even bring me here. He had to work through an insurrection, a pandemic, and I can't even, I mean, there's a book in there. But I think the short of it is, I think we can be optimistic because we know that we, the American people, we can determine the path, whatever that path may be. If we want it to be a certain way, if we think certain things are more important than others, we can't sit at home. We must go out. We must do what we can in our lives in whatever ways we can to educate, enlighten, to fight, do whatever it is, to teach, whatever it is, to make the future a better place. Yes.
Aside from the seeming judicial adoption of the ideology that was sort of laid out by Jerry Falwell and his group, the majority and the progeny, on these hot button issues of women's rights over their body and the role of church state and the other hot button issues that we seem to focus on. There's a myriad of other issues
Yes.
involved in the law
Yes.
that affect our lives. And my question is, what is the influence that we can discern as to getting people with that ideological bent in the majority, in the judiciary, at the court level, and on these other issues? How does it manifest itself, and how should we be concerned?
I just want to make sure I understand the question. When you talk about the thing, I guess the attitude that manifests itself, which attitude are you describing?
Well, because people are chosen primarily because of their theological
Okay.
adoption and embracing these ideologies as well.
Well, it's a good question, and I don't think there's any simple answer to it. I think that one of the things that we ought to consider is that how much change is going to happen over time in spite of the court. And I think the answer is a lot. Demographics in this country are changing. And as those demographics change, I think it means the American people are going to change, of course. And it doesn't, I'm not suggesting there's going to be this wave of kumbaya and everybody's going to be happy in one tight family. What I mean instead is the path of this country is sometimes not predictable. The future may not be predictable. But I think that as generations come and go and as change happens, I think we're going to see a different kind of enlightenment and a different kind of attitude towards a lot of different issues. And I'll give you one example of that. You're right, there are a number of different areas I didn't talk about, and that's partly because of time limitations. And there's, of course, a lot at stake. But here's just one example, and it has to do with gay rights. When I was in college, I happened to have a very good friend. He's still with us today. He's been a great public leader. His name is Evan Wolfson. And I remember Evan talking about his senior paper. Now, I'm talking last century. Evan's senior paper was about a right to marry for people who happen to be gay. And I remember walking across campus with him thinking, wow, Evan, that's pretty bold, And it was to Evan that I sent an email the day the Supreme Court decided a case called Lawrence, not just Lawrence versus Texas, but later Bergeville versus Hodges. Bergeville is the key case. When the Supreme Court of the United States upheld a constitutional right to marry, regardless of whether you're a man or a woman. And I sent that note to him saying, I guess you get an A, Evan. He didn't get an A back then. But why do I tell you this? It's because he had a vision. It's because he had a sense of what might make a difference down the road. And Evan's view was that it's a matter of people getting to know people. It's not a matter of highfalutin law or anything in the abstract. It's just recognizing that people are varied, and you will have friends and family who might be gay. You may know it, you may not know it. And I can tell you the generation that's growing up now knows it. They live with it. This is the world they have known and they are growing up in, and they don't have a problem with it. That's part of our future. That's going to happen. I haven't asked Evan what else is going to happen.Maybe I should. But the point is that I think there are reasons to think that's ultimately a good thing. I obviously don't think that's going to destroy traditional marriage. It's never made a difference in our marriage. I don't know why it would, or why it should, and I think that, but I think this is what we can expect will happen, is that in spite of whatever, let's say, closed-mindedness there may be, insofar as some justices are concerned, the American people are going to grow. They're going to grow up. And when they grow up, they will be more sophisticated and more open-minded than the people who existed before. That is going to be the case. And that means the future will be different than what we expect. Yeah. Yes?
I just have one question. I heard Robert.
Yeah.
Just recently, I think everybody's pretty much aware of it, Gorsuch decided to have a private meeting with the Coding Society, and it was the press, and so no one really knows. Yes, it's probably, let me just take on that a little bit. So it's probably going to come out because there's probably a waiter or a bartender that probably recorded everything.
Yes.
But, the idea that a Supreme Court justice would do that is kind of shocking to me. I practiced law, as you know, for a long period of time, and it just surprised me that would happen.
Yeah.
And so what I wondered about is, do you think is there any chance that Roberts could look at that and say, maybe I should change my role a little bit, maybe we should have some kind of code of conduct, or have some agreement among all justices, that it's just a bad precedent for the liberal judges to go do the same thing. It's a little bit different though when you have the majority there, but do you think there's any chance of that? I don't know Roberts, but he seems to be fair at times, and sometimes it goes over on the other side, so.
No, I appreciate the question, and you and I had talked about this beforehand. I smiled a little bit and laughed a little bit because the current article I'm writing is on a code of ethics for Supreme Court justices. I'm writing, my current project is writing about a code of ethics for Supreme Court justices. So it's something I've been thinking about a great deal. I've been working with Senator Leahy on that for more than a decade. Just to bring everybody else up to speed, every judge in the country, state or federal, every judge in the country except the 9 Supreme Court justices are subject to codes of ethics. You have to think about that. When you become a Supreme Court justice, you are suddenly liberated from having to comply with a code of ethics. And what happens then? Well, Brett Kavanaugh, not long after his confirmation, gave the annual speech, or gave the speech at the annual meeting of the Federalist Society behind closed doors. You all may remember my former constitutional law professor, Justice Antonin Scalia, went on a hunting trip with the Vice President of the United States, Dick Cheney, about a week before the Supreme Court heard a case in which Cheney's power, as it related to sort of administrative agencies, was under scrutiny. Anybody guess how Justice Scalia ruled in that case? Just take a wild guess. Come on, you can do it. That's right. He ruled for Vice President Cheney. And Niels Gorsuch is doing exactly what you just said. He's scheduled to give a talk behind closed doors at a function that's going to include a speech by Vice President Pence, who I think is a candidate for president, among other things. Now, why would Justice Gorsuch not want us to hear what he has to say? I suspect one answer is he doesn't care because he's not subject to any code of ethics. The code of ethics for judges requires that, among other things, they do not in any way interact with or become implicated with political activity. When Justice Amy Coney Barrett stood up at a function held at the University of Louisville, honoring Senator Mitch McConnell, Justice Barrett stood up and, without any apparent sense of humor or awareness, said justices are not political. My thought was, are you at all aware of where you are? Justices have a remarkable ability not to be self-aware. There are people, and this does happen in Washington, it should not surprise anyone, I doubt it will, that when some people get to Washington, they are remarkably arrogant and do not care what anybody else has to say to them. And off the record, I will tell you, I think this happens to Democrats a little more than it does to Republicans. This is one reason why I'm happy to see Washington in my rearview mirror. That arrogance in people of power is a horrible thing to witness. And that is, I think, is what you're seeing reflected in what Justice Gorsuch is doing. That he can go to what is plainly a political event and not think it poses a problem or question at all. At some point, the judge and justice should, in my view, put aside and away some parts of their lives. And the first and most important is anything remotely political. A judge is the embodiment of law. And for a judge then to be participating in anything that is political is, I think, acting outside the scope of their power and undermining their official role under our Constitution. It is not enough to say, this is the other thing I hear a lot as a law professor and other things. I think one of the most popular arguments people make these days is, what about? Well, in the midst of President Trump's 2 impeachments, well, what about Obama? Obama was torpedoing the Constitution and, taking our guns, and I don't know what else he did. I have to tell you that you're going to get credit for this, continuing legal education. That is not a legal argument. In a legal argument, the fact that somebody might have gotten away with something over here doesn't make this person over here innocent. That's not how it works. And so a long way of saying, I think it is long overdue for the Supreme Court of the United States to be subject to the rule of law, subject to codes of ethics. And I think a model, quite frankly, it can be found in the state of Alabama. Not once, but twice. In the state of Alabama, the Alabama Bar Association declared that the Chief Justice of the Alabama Supreme Court should be removed. That is a remarkable and, I think, incredibly significant thing that those lawyers did. They stood up for the integrity of the judiciary, as I think should happen with any justice. I think the worst quality of any leader is arrogance, is the sense that I don't have to do what you do, that I don't have to be held accountable for what I do, that I am above and apart from the law. That will be the end of the Constitution and of the rule of law. And as somebody who's devoted his life both to his family and to the Constitution, I would not support that. I would not allow that. If you care about the future of the country and you care about the future of the Constitution, then everyone, it's not asking too much, everyone should be subject to the accountability, meaningful accountability. Yes, ma'am.
I'm not a scholar, so I don't know.
I'm not either. It's okay.
Can Congress impeach a Supreme Court justice?
Yes. Congress has the power to be able to impeach a Supreme Court justice. Well, the
They did it in Alabama. I was wondering.
yes, they did it in Alabama in part. So in Alabama, I'm talking as if we're not here in Alabama, but you know, in Alabama, because we're talking about a state court judge, it would have been probably true for federal as well, but for a state court judge, the critical thing had to do with whether or not the Chief Justice was complying with the judicial canons. And the conclusion was he was not. Those canons require, among other things, impartiality, refraining from politics, those very things that Moore had. Yeah, I mean, he lacked, you know, he was partial, he was involved in politics, he disregarded the rule of law when a federal judge and a court of federal judges said, you must abide by the First Amendment, which means you cannot erect a gigantic monument to the Ten Commandments in the courthouse. And Moore said, I don't pay allegiance to you. I just follow the Constitution as I read it. And the federal judges around the country said, no, that's not your job. Your job is to follow the Constitution as it's understood by the Supreme Court and we other federal judges. And that means if there's a decision by the Supreme Court that says the Ten Commandments may not be established as a monument in a courthouse, you judge may not do that. My own law professor, Antonin Scalia, used to say that if you as a person do not believe in capital punishment, if that's your belief in philosophy, then don't become a judge. He felt as a judge or justice, capital punishment was legal. That was his view. But he felt like if he had a conviction, religious or otherwise, that somehow capital punishment was wrong and therefore he could never lend himself to approve it, then you shouldn't do it. Robert Cover, who was a very famous and beloved law professor at Yale, wrote a book about the judges during the period that led up to the Civil War. How should lower court judges handle issues of slavery? And one of the conclusions is, if they didn't like what the Supreme Court had said in Dred Scott, they should not be judges. It's not that hard. The problem is people want to be judges. The problem is they want to be president. The problem is they want to be able to tell you how to live your life. And all I can say is I hope they can do that while respecting the rule of law. So for a federal judge, the way in which, or justice, the only way you could get removed is if you committed an impeachable offense, treason, bribery, or other high crime and misdemeanor. It would have to be some kind of serious misconduct. And it could be, it depends on what, it could be, it depends on what the political thing is. If, for example, we had a Supreme Court justice show up at a political rally for a president and say, oh, you got to vote for, candidate X or candidate Y. I'm on the Supreme Court, you got to trust me. If a Supreme Court justice did that, I would not have a problem supporting a movement in Congress to impeach and remove that person from the federal bench. Period. It's that simple. Now, I could give you an entirely different talk about impeachment, which we've gotten all to know relatively well over the last few years. I'm not sure people want that because there are serious questions about whether or not impeachment itself is effective and meaningful. I won't go down that road unless I'm dragged.
Mr. Gerhardt, and on behalf of the congregation, this has been.
Shut me up.
This has been wonderful. I just want to thank you on behalf of all of us for gracing us with your presence. We're honored that you made it here, and we welcome you back home. Thank you very much.